adjust this a little bit. There we go. So I wanted to go over this order from the judge regarding the Bootlicker FAFO case that was dismissed because the state didn't show up. If you haven't seen that arrest, the playlist is all in order from the arrests to the whole event uncut, up to my arrest from my own perspective. Thank you, Lucica. I appreciate that. So check out that playlist. The last update is the last video in that playlist, and that's when I read the state's motion to reconsider the dismissal. So what I have here is my response. So if you guys don't want to hear that, it's lengthy. I touched on every point that the state made, and then we'll hear the decision, the final order of the judge. So I said, here's Frank Negus Staples in pro se capacity and respectfully request this court to affirm the dismissal and do so with prejudice. In support of this motion, the following is set forth. The defendant was charged with breach of bail after his arrest on a violation level disorderly conduct. A violation offense is not criminal in nature, and therefore breach of bail conviction is impossible. There are no conditions for release regarding a non-jailable offense. One cannot be held in jail for such crimes, particularly when the bail conditions themselves are unconstitutional and excessively drawn out to act as a way to prohibit my own self playing a role in the political process. Moreover, these bail conditions were an attempt to instill an unwarranted protection/restraining order without getting an actual protection/restraining order. Why? Because the state's goal is to lock me out of the political process. There is no complainant in the case. The state allowed me to stay at the legislative office building for the entire meeting, which was hours long. You can see it all in the playlist. Never asked me to leave, not once. DeLuca was actually stalking me the entire time. You can see, if you want to watch it at like a high speed, every once in a while I pan over to catch the same guy. That's DeLuca, following me around the whole time that day, and he was the one who arrested Teresa and I on 10/13 for the New Hampshire 9 arrests, right? So he was stalking me the entire time. He never said anything about me trespassing or anything like that at the very end until I started calling them bootlickers. So the state has tried to combine this case with an unrelated case, 429-3652. And that's just bad scheduling on the part of the state. Both cases needed to be tried separately and not done in a rushed process. The state wants every advantage for themselves while disadvantaging me the entire way. I don't believe that O'Leary's scheduling problems are a good excuse to give him another free pass. He wasn't even at the original arraignment on 1/14/2022, which alone is enough to have this case dismissed. O'Leary and his past anticipations have no bearing on the matter. Water under the bridge. Again, that's his fault for having poor time management and scheduling errors. If I hadn't shown up there, what would have happened is a bench warrant would have been issued, and we all know that. So I was never given notice that this case was ever scheduled to start immediately after 3652, and I didn't have witnesses or anything. So I'm not sure why O'Leary thought this case would be heard following the conclusion of 3652. There wasn't even enough time to get started, therefore this case was going to be rescheduled no matter what. O'Leary admits that he reviewed his calendar for conflicts. O'Leary admits that on June 13th June 13th was his preferred date. And then he goes on to say that he dragged and dropped June 13th as a placeholder, showing that he is fully aware of the trial date, time, and place. O'Leary admits receiving confirmation of his preferred date, June 13th at 9 a.m., which was sent out to all parties, including myself, by the clerk of courts, specifically referring to an all-day trial, not a half a day, not a late start, but a full day. O'Leary again admits that he was fully aware of the 9 a.m. start time on June 13th, 2023, with a lunch break at noon and a restart at 1 p.m. Now O'Leary expects us to believe that Ms. Castle sent electronic reminders to O'Leary and his witnesses, but that somehow only O'Leary's reminder notification was the one that failed. The question here is, whose responsibility is it to show up on time? Is it O'Leary's job or is it Ms. Castle's? Why were O'Leary's witnesses there on time, yet he wasn't? Next, O'Leary wants us to accept that there are mysterious technical glitches that were beyond his control. The question is how O'Leary was on time for all his other cases and why this time is any different. Unintentional scheduling errors aren't great excuses to avoid providing due process. It's highly suspicious that this is the only case O'Leary had with these issues. He's not claimed that any recent new Outlook programming or upgrades were the cause. This is the same system that he's been using. O'Leary then tries to blame his conversation with Vanessa Gelinas for his mistakes. He even admits that he saw DeLuca in court clothes and that Sergeant DeLuca walked by my office heading out to drive to court. How is it possible that the Outlook system worked for him prior and also for everyone else? Moreover, the trial notice was mailed out to all parties and O'Leary was the only one there who wasn't present. O'Leary claims Mark Barrett called him at 9:12, although the court is surely aware that DeLuca was the one that said DeLuca had just gotten off the phone with O'Leary. So was it Barrett or was it DeLuca that called him for his tardiness? I don't think it really matters, but O'Leary's story here is full of holes and appears to have been written by a third person for him. Additionally, O'Leary now says that he had it on his calendar for 12:45, which is 15 minutes later than the alleged 12:30 start time that he claimed to have scheduled in his motion point 11. He expects us to believe that he had a start time of 12:30 but planned on being 15 minutes late at 12:45 in point 13. Clearly, by his own words, one can see the inconsistencies and discrepancies with his explanation of his failure to appear. Again here, O'Leary says explicitly that he received a second phone call, this time from DeLuca, which I think is important because it exposes the blatant and coordinated dishonesty between O'Leary and his witnesses. I reiterate that it was DeLuca who said that DeLuca himself got off the phone with O'Leary, but then O'Leary says DeLuca was the second call. Given the great details O'Leary has put throughout his motion here, I can't believe that he could confuse these things. A simple in-camera review of O'Leary, DeLuca, and Barrett's phone records would clear that up, right? In-camera means that only the judge looks at it. He says that they were using state phones, whereas if the court is considering a grant of the state's motion, I would ask for a review of such records. I would also like to question Ms. Castle directly in regard to the Outlook scheduling question. A lot is implied here that may require a deeper inquiry. O'Leary asserts, but we don't really know, that he would have been ready to proceed by 9:30, but there is no evidence that he showed up to court that day at all. Is there a video of when he actually arrived on June 13th? Did he just turn around and go back to his office? Did he come and speak to the clerk and try to file his motion immediately right then? Was he in Texas or on the moon? We don't really know. So O'Leary asserts that he was ready to proceed with his trial on 5 prior occasions. Again, O'Leary had scheduled this unrelated case with another case that was already in process. If anything, this shows us that O'Leary has a difficulty with his time management skills and may need to partake in some sort of remedial course in order to brush up. Those 5 prior occasions when O'Leary claims to have been ready to proceed with this case are irrelevant because there was a motion to dismiss before us that he never responded to. He still has not responded to it, and that motion to dismiss that I filed would be the first point of order, as it could have been could still be dispositive of the case entirely. Moreover, irrelevant because the day he needed to be prepared was June 13th at 9 a.m. Of note, I was there with all my witnesses, my papers, and my videos, on time and ready to proceed in my defense and argue my motion to dismiss for the fact that the state was not present for my original arraignment on 1/14/2022. And I never received any complaint until months after my initial appearance, when it's, I won't get into that. So I submit that O'Leary has a nasty habit of being late and misscheduling his obligations as a public servant. This is an embarrassing waste of the court's time. We can't really know if there was a genuine, unintentional computer calendaring error unless we conduct a hearing and ask Ms. Castle. O'Leary has not submitted a sworn affidavit regarding the claims here. There's no affidavit from Ms. Castle. There is no proof to support his claimed reasons by failing to appear. I think that O'Leary is correct in that he deserves a citation for his tardiness. I assert that my rights were prejudiced in that under New Hampshire Part 1, Bill of Rights, Article 14, explicitly states we're to receive right justice freely, completely and without any denial, promptly and without delay. It's very simple. Again, if I were late like that, there would have been a bench warrant. O'Leary should receive a sanction for his violation of my legal remedies. Moreover, the Bain 145 New Hampshire 367 case is a horse of a different color and not on point. There were entirely different factors in the Bain case, such as a motion to continue had been filed by the state, as well as misconduct alleged by the judge. That's not what happened here in this case. The state was also there on time. Moreover, the Cotel 134 New Hampshire 275 case is not on point either. As the opinion goes, the state appeals the decision of the Superior Court, Murphy J., dismissing 4 indictments against the defendant, Kevin Cotel, to punish the prosecutor for failing to comply with a discovery order. We reverse and remand, whereas neither of the cases cited by the state are applicable in the instance case. O'Leary is boldly putting forth an obvious paper tiger. Neither cases had anything to do with the prosecutor failing to appear multiple times in a case. Not only failing to appear at the arraignment, but also failing to appear at trial. I expected to proceed without delay, as did the court. Ultimately, O'Leary wishes for us all to ignore Part 1, Article 14, and twist it to mean something other than it does. That is the right. The right in his tardiness was the prejudice. Right? The promptly and without delay is quite clear. Wherefore, I beg your honorable court to A, have a hearing and full inquiry into the claims made by the state. B, affirm your initial dismissal with prejudice. C, sanction O'Leary for his tardiness. D, provide a written decision to reiterate the importance for all being on time in regard to Part 1, Article 14, and grant what it may be that the court deems just. So we'll get into that. So that's it. It's very short. There's no really... he sends a copy of the state's dismissal, and then it says, having reviewed the state's motion to reconsider and the accused's objection made thereto, the state's motion to reconsider is denied. Jared Boyle right there. So you can screenshot that if you want. But yeah. So that's it. That case is over with. It's another victory. Or like this, really, right? Anyhow, it's a victory. That's a win. And now I just got the appeal, 2 appeals, but the New Hampshire 9 case and then the disorderly conduct out in front of Sununu's house. So thank you all for checking this out. That's it. I don't want to waste too much of anybody's time, but I thought that was an important update. The case is officially over. Thank you. Have a good weekend or good night, y'all.